Hello everyone. So the recent issue of huge amount of cash being recovered from the official residence of one of the High Court judge of Delhi High Court has again brought to limelight the issue of judicial accountability in India, how to make judges accountable in India. So in this regard, we'll be seeing that what are the mechanism to make the judges accountable in India. Before we understand how to make judges accountable, let's first discuss one another important concept named as independence of judiciary. Because we are discussing this thing, reason being the way of holding judges accountable, it is slightly different than holding any other official accountable in India. So to understand that, let's first discuss how the concept of independence of judiciary. So you see, state in any democracy has three primary organs. One is legislature, another is executive, and the third one is judiciary. The primary role of a legislature is to make laws. The primary role of executive is to implement the laws made by legislature, and the primary responsibility of judiciary is to ensure that the laws which have been made by legislature are in accordance with the constitution, meaning they should not be violating any constitutional provision. Secondly, judiciary also has to ensure that executive executes those laws in accordance or in the spirit of that law. Executive should not violate the spirit of the law. So these two things have to be ensured by judiciary, and hence for non-effective implementation of the law or for law to violate any constitutional rights which have been given to citizens, people or citizens, they have a remedy to approach judiciary. So judiciary basically protects citizens against the excess of the state. When I say state, the two organs of the state is legislature and executive. Because most of the cases which are there in front of judiciary, state is one of the party, one of the litigant. Judiciary, which has been given the responsibility of protecting citizens' rights, it is very essential that judiciary remains independent of these two organs of legislature and executive. And hence Article 50 of Indian Constitution, it also talks about the same, that judiciary has to be kept separated from rest two organs of the state. So I hope this much is clear to you, that the purpose of independence of judiciary is, or why this concept of independence of judiciary is very, very essential, that judges, they mostly ensure rights of the citizens against the state itself, and for that they have to be independent of those two organs. In this context only, there are so many provisions in the constitution itself to ensure judiciary's independence. Apart from constitutional provisions, there have been some Supreme Court judgments also which have tried to safeguard the rights of judges. One such judgment is K. Veeraswamy versus Union of India and others case of 1991. Here what Supreme Court has said is that no criminal proceeding can be initiated against the judges of constitutional courts, meaning the judges of Supreme Court and High Court, till the time Chief Justice of India allows for it. Only when Chief Justice of India is allowing for it, any investigating agency in India can start or can proceed with the criminal cases against the judges, right? So the objective of this judgment was to ensure that judges, they remain independent. There is no pressure from executive on judges. Another such judgment is a judgment of 1995, namely in the case of Ravichandran Iyer. Here you should be first knowing that Constitution itself gives this safeguard to judges in India, that the conduct of a judge cannot be discussed by parliamentarians or by parliament unless there is impeachment process is going on in the parliament. Apart from that impeachment process, the conduct of a judge cannot be discussed by MPs in parliament. In this judgment of 1995, what Supreme Court has said is, Supreme Court has extended this constitutional prohibition which is there on Parliament to other bodies as well. Namely, they have said that all forums, groups, individuals and associations, including investigating agency, nobody can discuss the conduct of a judge either in the court or outside the court. Basically, again, they have tried to provide the immunity, they have tried to provide a shield to judges against external scrutiny, so that they are not under any pressure while while they perform their or discharge their duties. Because independence of judiciary is that essential, the way judiciary is held accountable is slightly different than the way members of other two organs of the state, legislature and executive, are held accountable. Hence, we will be discussing now how judges are held accountable when criminal cases are or criminal allegations are made against them. In such a case, the first remedy which is available is an in-house inquiry. What happens in in-house inquiry is that judiciary itself starts or initiates an inquiry. In such a case, Chief Justice of India, he creates or he forms a 3-member judicial committee. So, in the present case also against Justice Verma, CJI, Chief Justice of India, has formed a 3-member judicial committee. This 3-member judicial committee will start its investigation. In the meanwhile, if the allegations which are made against the judge are of very serious nature, CJI can ask for that particular concerned Chief Justice of that particular High Court not to allocate any work to the judge against whom allegations have been made. So, judicial work will not be allocated till the time investigation is completed, only when allegations are of serious nature. When this 3-member committee completes its investigation, and if they reach to the conclusion that the allegations or there is an element of truth in the allegations, then the CJI will be asking the judge to resign voluntarily. The judge himself or herself will be given a chance to resign. If the judge refuses to resign voluntarily, CJI, what next step CJI will be taking is, CJI will be recommending the President of India as well as Prime Minister to start impeachment process against the judge. So, CJI will recommend for impeachment of that judge. So, this is the first process, first mechanism which is available to hold judges accountable. Another process which is the process of impeachment, this process it is given in the Constitution itself. This mechanism it is given in the Constitution itself. Article 124 subclause 4 deals with removal of the judges of Supreme Court of India. Similarly, Article 218 deals with removal of the judges of High Courts in India. These two articles, along with Judges Enquiry Act of 1968, deal with the process of impeachment of judges of Supreme Court and High Court. So, what is this process is? Under this process, if in Lok Sabha 100 of the MPs they give in writing to the Speaker of Lok Sabha, or if in Rajya Sabha 50 of the MPs give in writing to Chairman of Rajya Sabha to bring or to adopt a motion for impeachment of a judge of Supreme Court or High Court, then Speaker as well as Chairman have this discretion whether to accept this motion or not. If the motion is accepted by the Speaker or Chairman, a 3-member committee is formed, a 3-member judicial committee is formed, and then this judicial committee investigate the matter, investigate the allegations against the particular judge. If the committee says that whatever allegations which have been made against the judge are true, if they reach to this conclusion, then Parliament is asked to vote. If in parliament 2/3 of the members who are present and voting, or 50% of the total strength, whichever is higher, if these many MPs of both the houses separately they vote in favor of the resolution, the impeachment process is completed from parliament side, and hence if parliament passes this resolution, President of India will then be asked to remove the judge. So I hope the process of impeachment is clear. Basically, in nutshell, you can remember that by 2/3 majority both the houses of parliament, a judge can be removed. So these are the options available to take actions against the judges of higher judiciary. But the thing is, since the time of independence in India, no judge has been impeached so far, right? So even though the process of impeachment has been initiated sometimes, but never ever a judge has been impeached by this process, which makes sometimes people believe that this process is not enough deterrence for these judges not to do or not to indulge into corrupt practices. And hence, to stop corruption into judiciary, there are some suggestions also which are suggested by legal experts. One such suggestion is that judges in India, for them it should be mandatory to declare their assets. Right now, to declare asset, it is a voluntary thing for judges. If they want to declare, they can declare. If not also, then there is it is not legally binding. Right now, the judges in India, they declare their asset to the Chief Justice, but not to public. Few judges voluntarily they do it, but rest of the judges, they only submit this data to the Chief Justice. So that is first suggestion, that it should be mandatory for judges in India to make their assets public. The second suggestion which has been suggested by many experts is the judgment of 1995, which prohibits others to not to discuss the conduct of judges. This judgment should be taken back by Supreme Court. It should be allowed by free media to discuss the conduct of judges, so that they also come under public scrutiny, and there will be a deterrence for these judges also not to indulge into corrupt practices. So these are two suggestions, these are two reforms which can be brought to reduce the level of corruption among judiciary. If you people also have something in mind which can, some suggestions which can help in reduction of corruption in judiciary, you can mention in comment box. Thank you so much for watching this video.